seated. Mr. Breacher.
Good morning, Your Honor.
Good morning.
Sean Breacher from Young Conaway on behalf of the debtors. Your Honor, we have one matter on the agenda scheduled to go forward, and that is the ninth supplement to the list of ordinary course professionals, specifically the debtor's request to retain Yanis Ramos as Mexican labor counsel for the debtors. Your Honor, we do have in the courtroom today Mr. Robert Wagstaff. We did file a notice of his participation as our witness. If Your Honor would be so inclined, I would propose to put on a brief proffer of his testimony in support of the retention.
Very good.
Thank you, Your Honor. As mentioned, Mr. Wagstaff is present in the courtroom and is available to take the stand if the court has any questions or if any parties in interest wish to cross-examine him. Mr. Wagstaff would testify. He is the Chief Restructuring Officer in these Chapter 11 cases and a Managing Director of Riveron Management Services, LLC, the debtors' financial advisory firm. Riveron has been assisting the debtors with their operations internationally, including in Mexico. Specifically, Riveron has assisted the debtors with the retention of ordinary course professionals in Mexico to address various legal and accounting needs. Mr. Wagstaff would further testify that the debtors require the expertise of labor counsel in Mexico to handle various legal issues with respect to present and past employees. First, the debtors' Mexican entities have approximately 1,012 employees. The debtors require the expertise of counsel to handle various ordinary labor issues that arise in connection with operating their parks, as well as to advise Riveron and the debtors regarding labor matters that potentially may impact various transactions that the debtors are negotiating and considering as part of the resolution of these cases. Additionally, the debtors need labor counsel to address litigation matters that have been brought against the debtors by former employees, including Concepcion Esteban Machado and Valeria Margarita Albor Dominguez, the objecting parties to the OCP retention at issue today. Mr. Wagstaff would further testify that Yanis Ramos, the debtor's choice of labor counsel, is the best choice of counsel for the outstanding labor-related legal matters in Mexico. The debtors had Mexican labor counsel that had provided legal services to the debtors and the company's prior management. The debtors determined that it was necessary and appropriate to retain new labor counsel as Mr. Strom and Mr. Wagstaff took control of the company. The debtors initially selected another firm as their Mexican labor counsel, to which Ms. Esteban and Ms. Albor also objected. While the debtors did not agree that these objections had any merit, for a variety of reasons, the debtors chose to switch their choice of Mexican labor counsel to Yanis Ramos. Mr. Wagstaff would testify that Yanis Ramos is a firm comprised of disinterested professionals that are qualified to represent the debtors in various legal matters in Mexico and do not have any conflicts with respect to any of the firm's former or current representations, nor with respect to the matters for which they are being retained to represent the debtors today. Mr. Wagstaff would further testify that he believes the Yanis Ramos fees are appropriate, considering the circumstances of these Chapter 11 cases. Specifically, Mr. Wagstaff believes that Yanis Ramos' fees are market for the type of work they are doing in Mexico and are standard considering the rates that they charge other clients. Given the circumstances of the company, such as the company's restructuring as a result of the lack of liquidity and the company's defaults under the pre-petition note purchase agreement, as well as the litigation from Ms. Esteban and Ms. Albor, the estimated run rate reflects what the debtors believe is a substantial amount of work that Yanis Ramos has needed to do and will need to do to advise the debtors and their principals regarding their obligations under Mexican labor law and to defend the debtors' position with respect to litigation. Mr. Wagstaff would further testify that the need to retain Yanis Ramos and the estimated monthly expenses also relate in significant part to defending the company in respect to that litigation filed by Ms. Esteban and Ms. Albor. Both objectors were former employees of the debtors prior to the transfer of governance controls to Mr. Strom and Mr. Wagstaff. As Mr. Wagstaff noted in his declaration, which is found at docket number 344, which was filed in support of the debtors' second motion to find Mr. Albor and Ms. Esteban in violation of the automatic stay, Riveron found copies of backdated draft documents prepared by Ms. Esteban after the petition date that purported to transfer the debtors' Mexican assets to a non-debtor controlled by Mr. Albor. Further, despite the court having entered an order directing Mr. Albor to turn over the various legal records related to the debtors to Mr. Wagstaff and his team, Mr. Albor and Ms. Esteban refused to provide access to those documents, which were maintained in a locked room that Mr. Wagstaff understands was only accessible by Ms. Esteban. Ms. Esteban refused to turn over the debtor's records unless the debtors granted her a general release of all liability for her actions and a guaranteed severance payment of 12 million Mexican pesos. After a mediation session, Mr. Wagstaff observed via video surveillance that Ms. Esteban entered the company's headquarters and left the building with a box containing unknown contents. Mr. Wagstaff would testify. He reviewed correspondence sent by Ms. Albor, instructing employees not to cooperate with Riveron and not to provide information to Riveron after Riveron obtained access to the company's headquarters, particularly with respect to the scheme undertaken by prior management to shift park revenues from debtor accounts to accounts held by a company under control of Mr. Albor, who is Ms. Albor's father. Based on all this, as well as other actions that have given rise to pending criminal cases in Mexico against them, the debtors believed that, and then believe, they had ample basis to terminate the employment of both Ms. Esteban and Ms. Albor, given their conduct as accessories to Mr. Albor's ongoing violations of the automatic stay, as well as their own stay violations, which were set forth in the debtor's second motion to enforce the automatic stay. Finally, Mr. Wagstaff would testify that Ms. Esteban and Ms. Albor sought and obtained injunctive relief from the Mexican courts that froze the debtors' bank accounts. Those actions in the past few months negatively impacted the debtors' ability to operate their business. It was critical that Yanis Ramos take immediate steps to remove those embargoes over the state bank accounts so that the debtors could continue to satisfy their obligations in the ordinary course that are necessary to run the parks, care for the animals in the parks, and pay the debtors' employees. That would be Mr. Wagstaff's testimony.
Okay, thank you. Is there anyone in the courtroom who wishes to cross-examine? I hear no one.
Thank you, Your Honor. So, Your Honor, that's the evidence that we have in support of today's request. The debtors are asking, Your Honor, to overrule the objections and authorize the retention of Yanis Ramos under the ordinary course professional procedures already approved by this court. The record shows the debtors need Mexican Labor Counsel and that Yanis Ramos is disinterested and qualified and that the requested fees are reasonable in light of the current needs of the Chapter 11 cases. Your Honor, this is a straightforward exercise of the debtor's business judgment under the OCP procedures. The objections do not rebut the debtor's business judgment or the propriety of retention with evidence. Rather, they rely on speculation and irresponsible accusations. The objections should be overruled. Mr. Wagstaff's testimony spelled out the Mexican debtors' needs for labor counsel to address ordinary labor issues and to advise Riveron and the debtors on labor matters that may affect transactions that the debtors are negotiating actively or considering as part of these cases. Additionally, the debtors need labor counsel to address the litigation that's been brought by Ms. Esteban and Ms. Albor, the two individuals who objected to this retention. Your Honor, the debtors, with the assistance of Yanis Ramos, are actively defending litigation launched by the respondents in further violation of the automatic stay. The work that Yanis Ramos has done included obtaining reversal of an embargo placed on controlador Dolphin bank accounts, which were placed on those accounts as a result of the respondents' labor litigation filed after the petition date. Mr. Wagstaff's testimony is that those embargoes placed on the debtor's bank accounts negatively impacted the debtor's ability to operate the business, making it critical for Yanis Ramos to act immediately to remove those embargoes so that the debtors can continue operating the parks, care for the animals, and pay their employees. Your Honor, this is not a retention to address hypothetical issues. The evidence shows an ongoing operational need for day-to-day labor counsel, transactional-related labor advice, and counsel to address this emergency litigation in violation of the automatic stay. Yanis Ramos is qualified. The firm performed an analysis of the parties in interest in the Chapter 11 cases and determined that there was no conflict with any current or former representations. We do have a representative of Yanis Ramos on the phone today, Ms. Edith Reyes, who filed a declaration in support, is on the phone today. Mr. Wagstaff testified that the firm's services have been essential, critical in fact, to protect the debtor's interest and their ability to continue to operate in the face of what could have been crippling embargoes on the estate bank accounts. To business judgment, Your Honor, the debtor's selection of Yanis Ramos is a sound exercise of business judgment. Mr. Wagstaff's proffer indicated that the debtors did have prior labor counsel associated with Mr. Albor's former management and determined it was necessary and appropriate to retain new labor counsel after Mr. Albor was removed. They selected Yanis Ramos. The debtors selected counsel in accordance with the procedures and concluded in their business judgment that Yanis Ramos is the best choice to address the outstanding legal matters in Mexico. With respect to the fees, which is a subject of the objections, Mr. Wagstaff testified he understands Yanis Ramos' fees to be appropriate and consistent with the fees that similar Mexican firms are charging. He understands that the fees that the debtors are being charged are standard considering the rates the firm charges other clients. Indeed, the rates at issue here, which are from $65 to $500 per hour, are significantly lower than the rates charged by U.S. firms for similar services. Your Honor, the objectors hint at allegations of misconduct or corruption because the anticipated run rate, in their view, is greater than the historical run rate. There's absolutely no evidence to support those allegations, and in fact, nothing could be further from the truth. Any comparison to the historical labor counsel cost ignores the current facts. Mr. Wagstaff's testimony is that the run rate reflects the substantial amount of work needed to advise the debtors on their day-to-day labor issues, but also evaluating Mexican labor law impact of potential transactions, given the financial situation of the company, and also defending litigation that was launched by the respondents. The proper benchmark is not the debtors. The proper debtor is not the acquired or historical period. The proper benchmark is what the debtor's present need is. The irony here, Your Honor, is that the substantial portion of that need arises from the various parties who are now objecting to the retention. The debtors had every reason to believe their termination of Ms. Esteban and Ms. Albor was justified to avoid ongoing damage to the debtors. Mr. Wagstaff's declaration, prior declaration, and the testimony today provides just some of the basis for that justification, and the debtors are prepared to defend those termination decisions. We will do so in the appropriate court. It's inappropriate, though, for the debtors, who are the very parties with whom the debtors are litigating, to seek to strip the debtors of their choice of counsel. Your Honor, we did this morning receive a reply from Ms. Esteban. I believe an email was sent.
I haven't seen it, and I don't need to.
Okay. Thank you, Your Honor.
It's not timely.
It's not timely, but, Your Honor, I do feel like I need to at least say, because Ms. Esteban has accused us of misrepresentations and false statements, I can't let that stand, Your Honor. She indicates that Yanis Ramos has been working on behalf of the debtors prior to today. That's absolutely true. They stepped in on behalf of the debtors without guarantee of payment to immediately address Ms. Esteban's ongoing stay violations to embargo the debtors' bank accounts. We're here today asking for nunc-pro-tunc relief, which is appropriate and standard. There are claims that she has a basis for her litigation against the debtors under Mexican law. Those issues are before a court in Mexico. She has the ability to pursue claims. Her reply claims that the debtors have acted in bad faith. It's simply not true. And in fact, to the extent that you get documents, again, they're untimely. The documents say exactly that. They say that there's ongoing litigation that has been stayed because one of the debtors has not been served by Ms. Esteban. It has nothing to do with bad faith by the debtors. And again, Ms. Esteban, as usual, calls out debtor representatives by name, accusing them of illegality and corruption, which in our view is really remarkable given Ms. Esteban and Mr. Albor's conduct throughout these cases and the criminal actions that are currently proceeding and the arrest warrants currently proceeding against both of them for procedural fraud in Mexico. The debtors are not pretending to be the debtors' representatives. As Ms. Esteban suggests, we are the debtors' representatives. Your Honor held an evidentiary hearing on this point last year. Nothing has changed. In fact, the Mexican courts have continued to uphold the authority of Mr. Strong and Mr. Wagstaff to act on behalf of the Mexican debtors. And any suggestions by Ms. Esteban to the contrary can and should be dismissed. Thank you, Your Honor.
Okay, thank you. Let me ask a question. I just want to confirm here. This is an ordinary course professional supplement and a declaration. It provides for an ordinary course professional cap of $50,000. And I assume that's, I didn't go back and look at the original papers, but I assume that's simply a cap on what can be paid without coming back to the court on a monthly basis.
Correct, Your Honor.
And Mr. Wagstaff will be reviewing the bills, and if he has questions about the bills, he'll handle that with counsel. But nothing, this is not a $50,000 a month flat payment for services that are rendered, correct?
Absolutely correct, Your Honor.
Okay, thank you. Okay, I know there were objections, but I do not see the objectors here in court. And I do not believe that I gave permission for anyone to appear remotely. If I'm wrong, somebody can tell me that I'm wrong. I hear no one. Okay, I've reviewed the papers. I did review the objections. I don't view the objections as a basis upon which this request should be denied. As I just asked to confirm, this is a request essentially to put a law firm on the ordinary course professional list. And early in the case, an ordinary course professional motion was filed. It was granted. There were a list of professionals. This professional was not on the list. The debtors are asking that this professional be put on the list. All the $50,000 cap does is let the professionals know, quite frankly, that if their fees are over that amount, then they will need to file a fee application with the court. Otherwise, their fees can be paid up to that amount in the ordinary course by submission to the debtors of a bill that itemizes the services that are provided. This is Labor and Employment Counsel. Clearly, the debtor who has 1,000 plus employees needs Labor and Employment Counsel to handle things in the ordinary course. The testimony, as was proffered by counsel of Mr. Wagstaff, is that Labor Counsel will also be involved in evaluating transactions that the debtor may enter into, which have labor implications. And then clearly, based on the objections, there is litigation in Mexico that involves former employees that requires labor counsel. So I am not here as a court looking at an ordinary course professional retention and peace partying and I-specking the services that they are provided. That is what the debtor is to do. And if the debtor believes there are issues, then those matters will be first addressed with the law firm. And then I suppose, if need be, though it's never happened in all the years that I've practiced and been on the bench, they can bring those issues to the court for resolution. But the need is clear. I'm satisfied that the cap, under the circumstances that have been testified to, is an appropriate cap. And I do not see the objections as a basis to not approve counsel. In fact, I think they support the fact that the debtor needs labor counsel. So I will grant this request. I don't know that it requires was there a separate order? It would be a little unusual, but let's see. Because again, we don't usually have these requests. If the debtor wants an order, you can upload one, and I'd be happy to. Maybe we should, given that there were objections. And I'll permit this firm to be added to the ordinary course professional list. Again, based on the evidence that was presented and having reviewed the objections.
Thank you, Your Honor. With respect to the suggestion that an order be uploaded, we think that's a good idea, and we will certainly do that for purposes of clarity.
Okay. Thank you very much.
Your Honor, we have nothing further this morning.
We're adjourned.